Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello, listeners. We're talking today about intellectual property rights in works generated by artificial intelligence, IP and AI. My name is Julian Dibbell, and I'm your host. I am a senior associate in Mayor Brown's Chicago office with a practice focusing on technology transactions. Our guests today are my colleagues Richard Assmus and Mark Prinsley. Rich joins us from our Chicago office, where he's a partner in Mayor Brown's intellectual property practice. Mark heads the technology practice in our London office. Welcome, Rich and Mark. Thanks for dropping by. Rich, let me ask you to just set the context for us. We hear more and more about AI in the technology space. Why is it getting so much attention, and what are the potential implications for intellectual property?
Sure. Thanks, Julian. So AI is something that we've been hearing about, I feel like, for decades, but for decades, the real applications of AI have consistently been 2 or 3 years away. And now I think we're at the point where many of these AI applications are having real world applications, ones that particularly in legal circles, in-house counsel need to grapple with because their clients are implementing AI in ways that actually affect the business. So I think one of the reasons that AI is getting so much attention now, particularly in legal circles, is we're getting to the point where there are real and not theoretical legal issues that arise, particularly with respect to intellectual property and the way companies are actually using AI.
Okay. So artificial intelligence, right? Like you said, we've been hearing about it for decades. It's been, giant supercomputers in the movies taking over the world. That's not really what's going on currently with business uses of AI. Can you give us some concrete examples of AI and where it might intersect with IP issues?
Sure. I think you're right. A lot of the AI things we've heard about before seem like science fiction. And today, those applications that exist are in some ways more prosaic and in other ways more momentous in that they have actual applications. So I wanted to give you just 3 or 4 examples of real world applications that are either in existence today or just on the cusp of existence. And these are both taken from examples we've helped clients with, as well as in some sense ripped from the headlines of applications that have been reported on. So one is, think about a media company that has replaced its human news editors for simple news stories. And the AI system takes press releases, historical news articles, and other public company data to draft short articles for publication on the company's website. That's something that is at or near happening. Another example that made the news just earlier this year is about researchers at a drug company that have trained an AI system to learn what molecules may have antibiotic effects from a database of antibiotics. That AI system then has been used to identify other potential molecules which the drug company is testing for therapeutic effects. 2 more examples I wanted to orient you to. Engineers at a turbine manufacturer have trained an AI system to design lightweight but strong parts, which then can be manufactured not using typical manufacturing methods, but using metal additive manufacturing. And then finally, and this is one that we've seen a lot of applications for, imagine that underwriters at a life insurance company have trained an AI system to score an applicant's medical records, thereby in some sense replacing human underwriters. All of those examples, they're not science fiction at all. They're things that either exist today or that will exist very shortly and that raise important legal issues.
Right. And a theme running through potentially is that in each of these cases, the AI, the artificial intelligence, is generating works that might or might not be subject to intellectual property protection. So how is intellectual property protection adapting to this new technology?
Yeah, I would say that it is, in some sense, struggling to adapt to this new world. And that's for one principal reason. Intellectual property law has been designed from the start to protect the fruit of human labor and human intellect. And the intellectual property law has always struggled to adapt to new tools. It had struggled, for example, to adapt to the optical camera. Before the optical camera, an artistic work was literally the result of a human hand. And there was some question early on whether or not a photograph would be subject to copyright protection, given that all the photography was push the button. It also had struggled to adopt with the computer in general. And AI does something really fundamentally different here. It really further blurs the line between the creator, the tool, and the creation. So if you think of the creator as the photographer, the tool as the camera, and the creation as the photograph, AI is really very much blurring those lines. And I think there's two strains of thought we see here. One is, hey, AI is just a tool, just like the camera is. Or the second strain of thought is that AI is fundamentally new and requires new changes to our intellectual property laws. And this can raise issues under both patent law and copyright law.
Okay, well, let's look first at patent law and what's actually happening on the ground. Has the U.S. Patent Office ever examined any inventions purportedly invented by AI?
Yes, it has. Just this year, the Patent Office really squarely analyzed a invention that was purported to be invented by an AI tool called DABUS, D-A-B-U-S. That AI tool was listed as the sole inventor of the invention in question. And I think not surprisingly, the USPTO confirmed what everyone thought was the plain reading of the patent statute, which is under US law, that inventor must be a human. An appeal is pending of that decision denying the patent, and it's, I think, very likely that congressional action will be required in the United States to permit an AI tool to be named as an inventor on a US patent.
Mark, I want to turn to you for the European perspective. How have these issues with respect to patents been approached in Europe?
Well, it's a good question, Julian. And interestingly, the UK Intellectual Property Office, which grants patents in the UK, the European Intellectual Property Office, and very recently the English High Court, have all now considered the DABUS application. There was, as Rich has highlighted, no human inventor. DABUS was an AI machine, and the applicant had deliberately identified the machine as the inventor on the application. On the face of it, though, the applications were for an invention for which a patent could be granted. So the only issue, and it deliberately, in a way, being taunted by the applicant, was could you grant a patent to a machine? In fact, the applications failed in both the UK Intellectual Property Office and the European Patent Office, although technically the UK application was treated as withdrawn rather than rejected. In both the UK and the EPO, the fundamental problem was that there was no human inventor. In fact, exactly the point the applicant was deliberately testing with the applications. The applicant had a number of arguments which highlight the problem of patents for AI inventions. And actually, these give a clue to what owners of AI inventions ought to look for when they're thinking about how they might get patent protection for what you might call an AI invention. The fundamental argument was that there was a requirement to identify the actual deviser of the invention, and also the person the applicant believed to be the inventor. The applicant, Dr. Thaler, believed that the machine was the inventor and filed the application on this basis. To do otherwise, he thought, would be to mislead the public, and that wasn't something he was prepared to do. The applicant actually noted that neither the European patent law or the UK patent law expressly prohibited the granting of a patent to a machine or made by a machine. The legislation does, however, as in the US, although perhaps uses a slightly different term, require the applicant to be a person and the invention to have been made by a person. I think Rich was saying in the US it has to be a human, but it's a person in the European patent legislation. And a person is not a machine, basically, is where we end up with both the European Patent Office and the UK Patent Office. The applicants also argued that if an invention made by a machine couldn't qualify for a patent, then the public would be denied the benefit of inventions being made available, being created by machines. In effect, I suppose they're arguing that a machine needs the incentive of the grant of a patent in order to make an invention, because that's the sort of classic theory about patents. You give someone an incentive, which is a monopoly, and if they have that incentive, they'll go off and make an invention and make their fortune. Whether that applies to a machine, of course, is a bit harder to say. In the UK, the Intellectual Property Office said, well, the fact that you can't get a patent isn't the end of the day. There are various other forms of intellectual property protection, like trade secrets you could use to protect your invention. Quite recently, only in the last few weeks, Dr. Thaler's appeal against the refusal of the grant of a patent by the UK Intellectual Property Office was heard by the English High Court. And the debate focused very heavily on the requirement that an invention be made by a person and not a machine. And it's a fantastically interesting judgment from a philosophical as well as a legal perspective. The judge did say that if a person arrived from another galaxy and made an invention capable of protection by a patent, he or she could have a patent. However, the requirement that an invention be made by a person was not satisfied until the invention was made by a machine. Quite unusually, at the end of the judgment, so after the judge has declared what his judgment is, he goes on in what you might call a postscript to give a bit of a clue about what you should do if you're got an AI type invention. He noted that Dr. Thaler expressly declared in advance that he wasn't going to make the argument that as owner or controller of the machine, he was entitled to the patent for the invention created by the machine. And that's because Dr. Thaler was deliberately trying to make this point. What the judge said was, I haven't been asked to rule effectively on that issue, and you mustn't see this judgment as being in any way prejudicing somebody advancing the argument that the person controlling the machine would be the person entitled to a grant of a patent in appropriate circumstances. So, whilst the Dabus machine patent application failed, if you can point to a human involved in owning or controlling the AI machine, which makes the invention, you may well have a good chance of satisfying the invention made by a person requirement, at least in the UK and in Europe. And I suppose from the point of view of drafting agreements where people are going to make inventions, it might be very helpful to start putting in recitals and statements about who will control the people in control of the machine, because you can somehow point to humans being involved, or in Europe, persons, then you must stand a better chance of getting a patent. Now, whether that obviously works for the sort of simpler machine learning type inventions. But when you get into what I think is deep learning, where the AI machine is making its own decisions, it seems a bit harder to say there's a person in control of what the machine has made. And so I don't think the debate around patents at least in Europe, for AI-assisted inventions is by any means over. I mean, as AI gets more sophisticated, the patent system is going to seem less suited, or perhaps more suited, depending on which side of the fence you sit on, for protection of those kind of inventions.
Well, that's a fascinating debate going on. I wonder to what extent do these questions extend over into the realm of copyright? How is the situation similar or different there?
Yeah, so the situation is in many ways quite similar under US law in copyright, in that copyright protection requires a human author. But I wanted to emphasize a couple of points in that regard. One is in some ways, how old this question is, and I'll give you some examples of that, and also ways to sort of work around this from a practical perspective if you have a work that is the result of an AI process, whether it be machine learning or something else. So first, how old is this question? The Supreme Court actually definitively determined that a photograph was subject to copyright protection in 1884, actually upholding a Civil War era statute that extended copyright to photos. And you can see echoes of that argument today with respect to AI. In 1884, in describing the counter argument, the Supreme Court said, "It is insisted that a photograph, being a reproduction on paper of the exact features of some natural object or of some person, is not a writing of which the producer is the author." End quote. That is really an echo today in the question about what constitutes authorship if, for example, what the author or what the creator did was to program the machine learning algorithm. I have one more quote that really goes to the heart of this. But for one bit of sort of old-fashioned language, I think you might think this quote was written today. And the quote is, "The crucial question appears to be whether the work is basically one of human authorship, with the computer merely being an assisting instrument, or whether the traditional elements of authorship in the work were actually conceived and executed not by man, but by a machine." I think that, but for the use of man to mean men and women, could be something that would be written today. But in fact, that was from the 1965 annual report of the Register of Copyrights, trying to grapple with computer technology. So I want to emphasize just how old these issues are, but there are workarounds to this. What the office says today, the Copyright Office says today, is it will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or invention from a human author. And so the way we think about this is, if you have something that is the result of an AI process, maybe you can name the authors of the computer program that carries out that process as the author, because it's not like these machine learning tools operate completely independently. Just the opposite. They're coded by experienced programmers, data scientists, and the like. And of course, they're programmed for a specific purpose. So we think one workaround to this for the time being, until the law changes, if it ever changes, is to try to figure out who are the human actors that were involved in the AI system and potentially use them as your authors for purposes of copyright in the United States.
Mark, is copyright and AI handled differently in Europe, and how are these AI issues being looked at internationally?
So again, I think it's in a way quite similar to patents and quite similar to the position that Rich explained for copyright. In Europe, the view is that copyright protects the expression of the intellectual creation of an author. An author is a human again, and it's the whole concept of copyright has been built up around a right for a human. And the human has various responsibilities, like they mustn't they have liability if they are libelous with their writing. But in exchange, they have some human rights. Actually, in the UK and a number of European countries, there has been some thought about the idea that works can be computer generated. That's not a new thing, that you can have a computer generated work. But interestingly, again, the law looks at that in terms of who is the author of that computer generated work, and the author is the person who makes the arrangements necessary for the creation of the work by the machine. And a person, as we've talked about in relation to patents, has to be a human. So it's all focused on the human. And clearly these issues are going to come up in potentially quite unusual ways with AI. So there is the example of the sports journalism being written by a machine which is given a few facts. I mean, there are other examples which you wonder about. You wonder about deep fakes, where an AI machine gets somebody to write in the style of a dead person, or to speak in the style of a dead actor. You know, who gets rights for that, and who is responsible for that? So the law is a fascinating work in progress on this particular point, I think.
Right. Fascinating questions abound. As we've been reviewing them and elaborating on them, we've also here and there been nodding towards, the question that I think a lot of listeners are having at the top of their minds: how do I, as a lawyer with clients, handle these issues coming up? How for lawyers out there who are considering licensing works generated by AI, what are the considerations that they need to keep in mind? Can we give them a roundup of those? How can clients protect themselves given the IP landscape for AI?
So I think there are a few clues. First of all, you should focus on protection of the elements that have human input as opposed to machine input, and you should always try to identify a human involvement in the creation of the work by the machine. As we discussed earlier, I think that's got a problem when you get down to deep learning, but maybe that's some way off. With stuff that's more kind of machine learning, then the input, the ownership of the input material would be something that you would look at. Controlling the machine would be something you would look at. And I think actually, if you have got such a genuine, AI machine which you can't point to human input in, then trade secret protection is going to be an obvious and important form of protection. I think that contracts need to be drafted carefully, identifying, as I said, human input and ownership of input and output of an AI machine. There are going to be issues around ownership of developments and improvements. And of course, there are going to be massive issues around the usual warranties and indemnities you get for non-infringement. Just suppose an AI machine produces something which infringes somebody else's patent. Who's going to give you an indemnity in relation to that? I mean, these are issues which people are going to have to grapple with. But I think the key pointer is to look for ownership of the input materials and to look for human input in the machine.
Well, thank you, Mark, and thank you, Rich. A very interesting discussion and a lot of implications for those of us working in technology and the law. Listeners, if you have any questions about today's podcast or anything else related to technology transactions in the law, please email us at techtransactions@mayorbrown.com. We will forward your question to the right person for a response. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.